Hi everybody, this is Jennifer Wilson, and this is my presentation for Ethics on Paper, and I've titled mine the Fee Agreement. First, let me start by saying that this is only an academic exercise created by a student and not a real retainer agreement or a real case. And in this presentation, I will be portraying the paralegal for attorney Barry Barrister. I am meeting with a new client, Miss Valerie Victim, and I'm going to go over the retainer agreement or the fee agreement with her today. Miss Victim, I'm glad to see you again, and I'm glad you could come in and meet with me today on this fee agreement. As you know, I'm Mr. Barrister's paralegal. I'm here to meet with you today to go over the fee agreement. Not an attorney, so I won't be offering any legal advice, but you've already met with Mr. Barrister a couple of times, maybe even 3 times, and you all have talked about your case and kind of what he thinks and what you think, and you all he's decided to take on your case. So what we've done is put together this fee agreement in accordance with the rules of professional conduct and the rules of the Tennessee Code. Because a contingency fee agreement is required to be reduced into writing. It can't just be a verbal agreement under Supreme Court rule. As you can see here, Rule 1.5C, we need, and that rule says we've got to put it in writing. So that's what we've done today. And we're just going to go paragraph by paragraph. You stop me if you have any questions, and otherwise we'll go through here. We shouldn't be but about 10-15 minutes, but I don't want to get in a hurry. If you've got questions, you let me know, and we'll do what we can to get those answered for you. As you know, we won't. This agreement won't take effect until you've signed it to say that we are going to go to work for you. And the scope of this agreement and the scope of our services is that you're hiring Mr. Barrister to represent you in a claim against Tammy Tortfeasor for an assault and battery action that occurred on or about September 2nd, 2017 at the Earth Fair, which I understand is a grocery store located at 140 North Forest Park Boulevard in the Bearden neighborhood in Knoxville. Mr. Barrister will represent you until a settlement, a judgment, one of the two is rendered either by trial, settlement, or arbitration, however, and he will oppose any motion for a new trial, or he will look at any post-trial motions that should come up under the terms of this agreement. But in the event you were to want to appeal for any matter, any judgment that comes down, this would not be covered under this agreement. You would have to meet with Mr. Barrister, and you all would have to come up with a new agreement for any appeal. So this is just for this case and for this matter. You are our client. We take confidentiality very seriously. You are protected by attorney-client privilege, and so no matter all the people that love you and are helping you, we will only talk to you unless in some extreme instance you tell us that there's somebody you really want us to be able to talk to, and you give us your express permission, but we prefer just to talk to you. And just like you expect us to give you our best in representing you and Mr. Barrister to be the best attorney that he possibly can, and we expect you to be a good client. We expect that you be on time for your appointments, that you be on time for any court dates, any depositions, that when we reach out to you, you communicate with us, and we respond, that you, if we ask you for some documentation, that you get it to us just as quickly as possible, because we're probably under a deadline of some sort. Keep us up to date on your address, your phone number. If you're going to be out of town for a week, check with us before you go and just say, hey, make sure that there's nothing that we expect to be coming up that we would need you for, that we couldn't get in touch with you or whatever. So just communicate with us, and we will do the same with you. Mr. Barrister is asking that you make a $500 cost deposit that will go into our escrow account, and that will be used initially for filing fees. any service fees that are required on the front end. And we will use that money for, whatever comes up. If we have to request any type of records, police records, just whatever we need, we would use your $500 first. And then potentially, once that's done, we may be contacting you and say, hey, we need you, to make another deposit into the escrow account to cover fees. If we did that, we would give you time to come up with that money. In this instance, our agreement says 30 days. We wouldn't expect it to, just come up tomorrow and say, we need you to run in here and hand us $10,000, or which would never be. But we would give you some time to get it in. We are only paid if a recovery is obtained. We only get paid if you get something. If no recovery is obtained, then you're only obligated to pay us for any expenses that we had in your case. We are paid a percentage of the net recovery, which means once a settlement's reached or a judgment is rendered, then we deduct the fees from that, and then we get a percentage of that net, what's left. So if you get a $100,000 judgment and there's $10,000 worth of fees, we're going to get paid our fees, but then our percentage is coming off that $90,000, not the full $10,000. So we bill on a net recovery. We'll give you a written statement when the time comes that shows what any judgment is, what the award is, either by judgment or settlement or whatever, then what the fees are, and then or expenses, and then what we get, and then what you get. So there'll be a total breakdown. You'll know exactly where your money's going. Now, in our instance, we break our fee schedule down in three time frames. If we're able to settle your suit before a lawsuit is filed, then we're paid 20% of the net recovery. If we file the lawsuit and then we're able to settle your case prior to 30 days, as you see here, before the date that it's initially set for trial or goes to arbitration, then we'll get 25% of the net recovery. If neither of those work and we have to go to arbitration or go to trial, then we get 30% again of the net recovery in this case. In the instance we had you were to discharge us or we had to withdraw for cause, then we would still be entitled to be paid a reasonable fee for what work we had done to that point that contributed to any result you ultimately got in this case. We will incur various costs and expenses in this case, and we will pass those on to you. We will only pass them on to you based on what we were billed. If we were billed $75 for a filing fee, we'll bill you $75 for a filing fee. If we were billed $300 for a deposition, we'll bill you $300 for a deposition. Really, the only difference is that it's kind of a variable is copying. We charge 10 cents per copy of any copies that we have to make on your behalf in filing or sending things out. And as far as mileage, we bill at whatever rate we have to drive to a deposition or drive to court, whatever any mileage that we have, and we keep up with all that, the date and where we're going, what we're doing on your behalf, based on what the IRS allows for to be billed or that you could claim on a tax return. And you understand we're going to use your $500 toward all this first, and then before we ask you for any other funds. Now, part of this could be that we had to hire experts or investigators. If so, we would meet with you first. We would tell you why we think we need them, what we expect them to contribute, and have some idea of what their charges would be. If it goes to arbitration, if the case were to go to arbitration, there's a fee. You would be responsible. The arbitrator gets paid for his services or her services, whichever. In that case, and then you understand that the court may, in the event of a judgment at trial, the court can rule that you get your court costs as part of the judgment. There's no guarantee they'll give us the full amount of what our court costs are, or our fees or expenses in relation to the case. The court may determine that this some other amounts reasonable, but you're still responsible to us for what we actually expend on your case, not just what the court gives us as part of the judgment. We'll send you periodic billing statements, and then if show you what we've got, and if you've got something on there, we expect to be paid within 30 days after you get the statement. You can discharge the lawyer at any time, or the lawyer can withdraw for good cause. Good cause, just so you know, in case of withdrawal, would be if you breach this agreement, you refuse to cooperate or to follow the lawyer's advice on a material matter or circumstance. That would make what we do, the attorney's representation, unlawful or unethical. And whenever we're done with our work, we expect to be paid. We keep files in our office for 7 years after we're done, and if you don't come and pick your file up in 7 years and 1 day, we have the right to dispose of the file without contacting you again. Nothing in this agreement is a guarantee of any judgment or any settlement amount. We've not made any guarantees to you of what you're going to get out of this. That anything that you all talked about is Mr. Barrister's opinion on what he thinks of this case, and there have been no guarantees on what you will get. These fees are not set by law. Our fees are agreed upon between you and Mr. Barrister. That's not some code somewhere that says you pay this amount. Even though there are regulations on how much an attorney can bill, and we are well within those amounts, and we meet the guidelines. We would never accept a settlement on your behalf without talking to you first. Make sure you're comfortable with it. Let you decide that isn't a settlement amount. You have the right to reject a settlement, but we will ask that you seriously consider all settlement offers, and we would talk to you about those. We only represent you in this matter, in this assault and battery case. If Mr. Barrister were to see something else come up that he thinks may be a cause of action that you have, he would tell you about that. He would say, I think you need to look at this, or I need you to think about this. And he would ask you to, he would instruct you or advise you to speak to another attorney on that behalf. We only represent you the assault and battery. But if something else were to come up that he noticed, he would tell you about that so that you would have time to contact another attorney. In the event you were to maybe get into a disagreement with, say, an investigator, about how much money's paid or something like that, that's a separate agreement. We would just plead that money into the court and let the court, and then you would have to resolve that matter. Though we only represent you in this assault and battery case. When the services are concluded, again, we'll have your file. You're entitled to your file if you want it, but we are entitled to withhold part of your file. Say you were to decide you didn't want Mr. Barrister to represent you anymore and you want to get some other attorney, we're entitled to withhold part of your file until our fees are paid. And we are under Tennessee Code annotated 23-102. Attorneys are granted a lien on any settlement or judgment for their work that they've done. So we have a right to get paid. Any proceeds will be deposited into our escrow account and held until we make sure the check is good, and then paid out pursuant to a settlement agreement that we talked about earlier. This goes on to say here that this is our entire agreement. There's nothing on the side that we haven't talked about. This is our agreement. And if any provision of this agreement were to be deemed unenforceable, that the rest of it is it will remain in effect. Any modification would have to be done, or any subsequent agreement would have to be done in writing, just like this agreement. Again, under the rules of professional conduct, a contingency contract has to be in writing, and we would make sure any changes would be in writing. The effective date of this agreement is when we go to work for you. So the date on here is for reference only, just to give us kind of a starting point. If we've already done something, if we've expended some expenses on your behalf and you decide you want to do this, and we've had to get some records that we would expect to be paid for that. But we go to work for you once you sign the agreement. And again, like I said before, we want you to be comfortable with the agreement. If you feel comfortable signing the agreement today, we'll do that. If you say you want to take it home and think about it. And I think Mr. Barrister's met with you, like I said, I think about 3 times, and I'm sure y'all have covered everything in here. But if everything's good, then we'll sign the agreement, and we'll get Mr. Barrister to sign it. We'll sign it in duplicate that way. You'll have a copy, and we'll have a copy of the same agreement. As for my class, thank you for listening to my presentation, and hope you all have a good rest of the week.